Getting a divorce in New York is actually simpler than you might think. One spouse must be a resident of New York for 2 years before a divorce can be filed. That restriction can be reduced to 1 year if the spouses were married in New York and either spouse is still a resident, they once resided in New York and either spouse is still a resident, or the grounds for divorce arose in New York. Also, there is no residency requirement if both spouses were New York residents at the time of filing for divorce, and the grounds for divorce arose in New York. Once the residency requirement is completed, a legal grounds for a divorce must be established. In New York, both general and no-fault divorce are acceptable grounds for divorce. No-fault reasons for divorce in New York are living separate and apart for 1 year under the terms of a separation agreement which is in writing and signed and notarized. Proof of compliance with the terms of the settlement agreement must be submitted when the divorce is filed. In addition, a copy of the agreement or a brief memorandum of the agreement must be filed in the office of the clerk of the county, or living separate and apart for 1 year under the terms of a judicial separation decree. The reasons for a general divorce are adultery, abandonment for 1 year, imprisonment for 3 or more consecutive years, and cruel and inhuman treatment. New York does not require a parenting plan for child custody. Joint or sole custody is determined according to the best interests of the child. Neither parent is entitled to custody. Additionally, there are no factors specified in the statute which dictate the circumstances around child custody. Health insurance may be ordered. Marital misconduct is not considered in child support decisions. There are specific child support guidelines in the statute and are presumed to be correct unless there is a showing that the amount of support would be unjust or inappropriate. The factors considered are the financial resources of the child and the parents, the standard of living the child would have enjoyed if the marriage had not been dissolved, the physical and emotional health of the child and any special needs or aptitudes of the child, the financial resources, needs, and obligations of both the non-custodial and the custodial parent, the tax consequences to each parent, the non-monetary contributions that the parents will make towards the care and well-being of the child, the educational needs of either parent, the needs of other children of the non-custodial parent. If the child does not receive public aid, any extraordinary expenses required for the non-custodial parent to exercise visitation rights, and any other relevant factors. Security may be required for the payments. New York is an equitable distribution state. Separate property, including property acquired before a marriage, and any gifts or inheritances acquired, is to remain with the owner. Separate property also includes any increase in value or property acquired in exchange for separate property. Marital property acquired will be equitably divided between the spouses based on the contribution of each spouse to the acquisition of the marital property, including the contribution of each spouse as homemaker, the income and value of each spouse's property at the time of the marriage and at the time of filing for divorce, the probable future economic circumstances of each spouse, the length of the marriage, the age and health of the spouses, the amount and sources of income of the spouses, the probable future financial circumstances of each spouse, the potential loss of inheritance or pension rights upon dissolution of the marriage, whether the property award is instead of or in addition to maintenance, custodial provisions for the children and the need for a custodial parent to occupy the marital home, the type of marital property in question, whether it is liquid or non-liquid, the impossibility or difficulty of evaluating an interest in an asset such as a business, profession, or corporation, and the desirability of keeping such an asset intact and free from interference by the other spouse, the tax consequences to each party, the wasteful dissipation of assets, any transfer of property made in anticipation of divorce, any equitable claim that a spouse has in marital property, including joint efforts and expenditures, and contribution and services as a spouse, parent, wage earner, and homemaker, and to the career and career potential of the other spouse, and any other factor necessary to do equity and justice between the spouses. Marital fault may be considered. Financial disclosure of assets and income are mandatory. Either spouse may be awarded maintenance without regard to marital fault based on the income and property of the spouses, including any marital property divided as a result of the dissolution of marriage, any transfer of property made in anticipation of divorce, the duration of the marriage, the wasteful dissipation of marital property, the contribution of each spouse to the marriage, and the career of the other spouse, including services rendered in homemaking, childcare, education, and career building of the other spouse, the tax consequences to each spouse, any custodial and child support responsibilities, the ability of the spouse seeking support to become self-supporting, and the time and training necessary. Any reduced lifetime earning capacity as the result of having foregone or delayed education, training, employment, or career opportunities during the marriage. Whether the spouse from whom maintenance is sought has sufficient property and income to provide maintenance for the other spouse. The age and health of both spouses. The present and future earning capacities of both spouses, and any other factors the court deems just and equitable. Finally, New York has no divorce mediation requirements or provisions. Visit us today at www.mydivorcepapers.com and click on New York at the bottom of the page. Let mydivorcepapers.com help you file for divorce today.